Hello, my name is Agnes Natkunda. I'm an assistant lecturer, faculty of law. I happen to be also an advocate of the High Court of Uganda and all court subordinate. As your trial advocacy instructor, today I'm going to be taking you through submissions, or what you may call your legal arguments. Like we told you earlier on, in trial advocacy, we are looking at how best you can have your art, your unique way of doing things. So trial advocacy is an art. It is not a science. So you're going to find that each person has got their own way of doing things in a unique way. Remember, as an advocate, you're called to aid. This is not your case, but someone who has been troubled by someone, by something, by anything, calls you as an advocate because you're trained and they are confident that you're going to do it much better than they can do it themselves. So you become a storyteller, and this is where submissions pick their backing from. You become a storyteller. You do not just tell a story. The story has to be told from the facts at hand and also the legal regime that governs the case that you're handling. We are going to be looking at the topic in brief, whereby I'm interested in taking you through the objectives, the introduction, how to plan your legal argument, drafting your submissions, order of addresses in criminal cases, then civil cases, then the purpose. In the middle there, you need to know, why do I need submissions? How important are they? What is the purpose? We have to look at it. Then how do you structure your final submissions? We're also going to look at the sample structure of the defense arguments and civil trial. Also, how to make effective final submissions. And also the style. You need to develop your own style of preparing these submissions. Remember, at the end of the day, the purpose of the submissions is for you to communicate as well as persuade. You make submissions, you summarize your case such that the judge, the judicial officer, is convinced with you that your client should win the case. To the objectives, basically this is to achieve the mastery of basic trial skills and also to know the art of preparing persuasive submissions. You do not have to prepare submissions. They have to be persuasive. Your duty is to persuade. You do not persuade in vacuum. You must be alive to your facts and also the legal regime governing the case you're handling. The introductory part of submissions or your legal argument, trial advocacy is a performing skill. So the best way to learn is to practice the various skills. And the skill for today is how to prepare effective submissions. So you need to practice on how to make submissions, as they can be oral or written. Submissions come up in both civil and criminal cases, and also when there are preliminary points, objections that are raised, you always have to make either oral submissions or written submissions. So it is always important that you understand submissions stretch way back from the time you meet a client. A client is going to narrate to you their ordeal. Then you're going to advise as you note down the facts that are being presented to you. You get to know the cause of action. Does this person have a cause of action? What is the law at hand? How best do I advise this person? Then from that point, you're going to draft the pleadings and take the matter to court. Urge your case out, and then from there to the end, you will come to preparing of these submissions. So before you embark on preparing your legal arguments or submissions, you need to you must be alive to your trial strategy. Let me give you an example. There is a case whereby a certain man had children. So on a certain day, he decided to gift actually one of the grandchildren land. He made a gift deed. There were witnesses to that effect. He called so many people. Then it is also told that he made another document whereby he was detailing how his land, the properties he was leaving behind, how they could be utilized after he passes on. So later when he passed on, before passing on, the two documents, the gift deed was handed over to the son, and also the other document that would guide the beneficiaries on how best to share the property was handed over to his brother. But when he passed on, his brother misplaced that document. So what he did, he called the people who were around and a few people and made the document. But now the document, it shows that the remaining land had been given to the girl, the daughter, who had stayed home, had not gotten married. Yet to the other brothers and sisters, they say, no, when our father made the other document, we were around. He said all this land, the remaining property should benefit all of us, not the girl alone. So a dispute came up. They went to court. So now, when you are alive to your trial strategy here, you're going to ask yourself, of course, this is going to take you to the Succession Act. What is the law on succession? For example, when you look at Section 20 of the Succession Act, a person dies intestate in respect of every property that has not been disposed of by a valid testamentary. You have that. Now you also go to the Succession Act under Section 189. It is also clear that no right shall be established in an intestate estate unless letters of administration have been applied for. So now you're going to ask yourself, having listened to my client's story, what trial strategy am I going to move with? These two sections are supposed to guide you. These are going to be your basis. So you need to ask having established such a scenario, you need to ask yourself some questions. What am I going to say at the end of the case? Which evidence must I introduce? So the answers you're going to get out of this are going to guide you on how best you're going to prepare your submissions, because we believe that a case is made or killed at the time of pleadings. When a client walks into your chambers and narrates to you their ordeal at that particular time, that is when your trial strategy should come up. What evidence am I going to adduce? What kind of the law am I going to base myself on to be able to be persuasive and also communicate? Because remember, at the end of the day, the judge is going to listen from both sides. Then look at the evidence or the submissions that are most effective, that are convincing, and is going to decide the case alongside that line. So, drafting your submissions are made both in civil and criminal matters. You've been studying criminal law, you've been introduced to offenses. So when you're going to prepare submissions, for instance, under criminal law, you're going to look at the offense. What offense? If your defense counsel What offense has your client been charged with? If it is murder, what are the ingredients of murder? You look at all the ingredients. Then when it comes to adducing evidence, what is the burden of proof? Who has the burden? To what extent is the burden? You analyze all that. You look at the evidence that has been adduced. Does the evidence touch on every ingredient? Because the law is clear. For you to be convicted, it should not be on the weakness of the defense, but it should be on the strength of the evidence that has been adduced by the prosecution. So your duty is going to be looking at the evidence that has been adduced by prosecution. Does it touch to all the ingredients? If it doesn't, then you're going to bring out all that in your submissions. Assuming your counsel for the state, you're the prosecution, your duty is to ensure that all the evidence you're going to gather bring out all the ingredients of the offense you've decided to charge the accused person of. So once there is the prosecution has closed their case, we normally make submissions on no case to answer, and in this case, counsel for the accused person is always given the first opportunity to make their submissions, and then the prosecution will reply, and also you'll make a rejoinder or make a rebuttal in respect of what they have submitted on. And that is actually in respect of the order of addresses in criminal trials, and this is actually provided for under section 112, subsection 3 of the Magistrates Court Act, Cap 19, where the accused person you're entitled to the right to reply. You can also refer to section 131, subsection 2 of also the Magistrates Court Act. Okay. So even in civil matters, you always have counsel for the plaintiff, counsel for the defendant, counsel for the applicant, counsel for the respondent, counsel for the appellant, counsel for the respondent. So counsel, the person, maybe I will say the person who brings the matter to court, that is the appellant, the applicant, or the plaintiff. Their counsel always be given an opportunity to make their submissions first. Then a reply from the opposite counsel, and you're also given an opportunity to rejoin. And so the submissions end at that. Then, just like I've told you, the major purpose of submissions is to communicate and persuade so that the judge or the judicial officer decides this case in your client's favor, meaning that you're going to do everything that is within your means to make sure that your client has a good case. How do you do this? Of course, I don't want you to concoct evidence, no. You remember, if you excuse me, to look at the previous classes in trial advocacy, you know we have the qualities of a good trial lawyer. You are not supposed to mislead the court. So when it comes to the main purpose of submissions, yes, you want to persuade, convince, to ensure that the matter is decided in your client's favor. But this is going to be based on the evidence you have. Do not concoct evidence. Analyze the evidence that you have brought to court. Because you owe a duty to court not to mislead it, not to give it false information, not to quote witnesses or clients. Look at the evidence that is in support of your case. Know the evidence you are going to adduce, the witnesses you're going to produce, the type of documentary evidence that you're going to adduce in court. So after you've done all that, when it comes to submission, you're going to analyze all the evidence that you have adduced. Then tie that evidence to the law. Like I've highlighted about section 20 and 187 about a person dying intestate. So connect that, look at what the evidence states, what the witnesses said, the documents you have adduced. For example, in this case, they produced this document. The document was backdated, but it is not signed by the deceased because it is not in dispute that this document was made after the deceased had passed on. But if it was a family agreement, why is it that some other members are disputing it? Then if yes, this document was exhibited in court, what document is it? Is it a will? Is it a gift deed? Who is the author? Who is the maker? Who are the witnesses? Is it a valid document? Automatically the answer is going to be no, this cannot be a document to dispose of property of the deceased. If at all the document was there and it cannot be produced, then you just have to go to the law and look at how property that has not been validly disposed of is supposed to be distributed. That is now, it becomes property of an intestate estate whereby someone did not leave a valid will, did not gift the land to anyone. There is no proof. So you must look at the evidence that you have to make sure that court is convinced to the extent that it's going to decide the matter in your client's favor. We now look at structuring the final submissions. This is how we make submissions. You're going to have the brief facts. Why should you have the brief facts? You need to tell the story because in the introduction, the judicial officer needs to know what exactly do you want and what is the story behind. Like in this example I've given you, we want the court to declare that the deceased died intestate, and as such, all the property that was left behind undistributed should be distributed according to the law. So you briefly narrate the story of what happened. Narrate the brief in the introduction or in the brief facts. Give the brief facts for the plaintiff. Also give the brief facts for the defendants. Why do you may ask yourself, why again do I have to make brief facts for the defendants, yet they are also going to make their own submissions where they are also going to have their own brief facts? This is the reason. There is always a tendency for lawyers wanting to give fake brief facts. So it is important that you capture both your facts and also the other side's facts. Then after that, you're going to look at, briefly talk about the scheduling. What points, what issues did you agree on during scheduling? Highlight the issues. Then before you come to resolution of those issues, make sure you talk about the burden of proof, because it is the basis now of this case. Then from there you'll go to every issue. For example, in this case, one of the issues was whether the deceased died intestate, assuming that is one of the issues. So what is the law on intestate succession? Which evidence have you adduced? So you must tie all that evidence together and come up with a conclusion that you want the judicial officer presiding over the matter to handle. So here we have the sample structure, which has the brief introduction, state the burden and standard of proof, tackle each issue, state the law on every point, then cite written law first, then also have case law. Then, for example, still in respect of the example I've given, we have this case of Israel Kagwa versus Martin something. It's a Supreme Court case in respect of the fact that a beneficiary does not need letters of administration to protect their interest under an estate. So you have to look at binding authorities. There are also those that are persuasive. The judge may not have to rely on them, but to some extent they might persuade him to agree with you. So you need to cite them as well. So now we go to the hallmark. What actually should an effective final submission look like? Clearly tell the court that is what you want. If you want the matter dismissed, make it clear in your submissions. If you want the accused person convicted, that is with your prosecution, make it clear. If you're counsel for the defense, for the accused person, and you want your client, the accused person, acquitted, say it clear and back it up with evidence. And make sure that you point out to all the important evidence. And if at all there are holes that you need to punch in the evidence of the opposite party, make it clear such that your submission flow in a chronological order. You do not have to confuse. Someone is on the 50th paragraph, needs to go back to the first page, does it. So let the submissions flow in a proper way that even the person going through your submission is not going to be misled. Then now we move to the style of presentation. The presentation, assuming each person has got, just like I've told you, this is an art, you're going to develop your own art of making submissions. I remember the other day we are looking at proceedings in court martial. There is senior counsel Karibala of Makerere University. When he's making his point, he tends to be calm. But you see in the same court martial, there was counsel Aaron Chiza. He was making his point on top of his voice. And I think that is his art. So when you to look at the two, they were representing the same person. But each person had their own way of doing things. So that is also how you're going to develop your own art. Are you a calm person? Are you going to make your submissions in a calm manner? Are you going to be this kind of advocate who submits with vigor? Look at the prominent figures we normally have in court, the Kabegas, the Mark Dismas Kabegas. Go to maybe to Road Mayor Lukwago, go to Chiza Aaron, go to others. How do they submit in court? Which style would you prefer to move with and why? And what makes you? Are you a calm person or are you the opposite? So it will also depend on who you are and how you want to appear in court. So what to avoid during final submissions? Avoid making improper statements. Make statements that are clear, that are backed up by the evidence, by the law. You're going to quote something, but you cite the wrong law. Even you find the evidence you're trying to tie to the law does not even match. So make sure that you make proper statements, you make proper citations. Do not submit from the bar. Understand your case. Make a critical analysis of it and make a proper submission. The other day I was discussing with my colleague. He reminded me of the African proverb which says that tears of a coffin maker can never be taken genuinely at burial. You can imagine So this is something you even need to think about. Assuming this was a case you were trying to advance. This is a coffin maker. He's busy crying. Someone has died. But it could even be true that the person, yes, my business is a coffin maker, but I'm hurt because we have lost this person. But another one, we look at it from a different point. I don't think these tears are genuine, because this is his business. If people do not die, where is he going to get money from? So when you make your submissions, the judge has a way on how they are going to look at it. Look at that African proverb of the tears of a coffin maker cannot be taken genuinely on burial. But you're going to say, no, a coffin maker is also a human being. They can also cry upon the death of someone, even after they have been hired to make for that deceased person a coffin. But another one is going to say, no, by the time you engage yourself in this kind of business, coffin making of all businesses, I think you're heartless, even if someone dies. Because for you, when you have challenges, that is your source of income. You want people to die, and you make money. Otherwise, thank you for listening to me. If at all there are no any questions, we are going to end this class here. Thank you for being good listeners. Cheers.